All rise.
Kosovo Specialist Chambers is now in session.
Good afternoon and welcome everyone in and outside the courtroom. Mr. Court Officer, can you please call the case?
Good afternoon, Your Honours. This is case number KSC BC 2020-07, the Specialist Prosecutor versus Gucati and Nasim Haradinaj.
Thank you, Mr. Court Officer. Now I would kindly ask the parties to introduce themselves, starting with the Specialist Prosecutor's Office.
Good afternoon, Your Honour, and to everyone present in the courtroom and remotely. Appearing for the Specialist Prosecutor's Office today are Alex Whiting, Deputy Specialist Prosecutor, Valeria Bolici, Prosecutor, Lena Peterson, Case and Evidence Manager, and I am James Patch, Associate Prosecutor.
Thank you, Mr. Prosecutor. Now I turn to the defense, and for the defense who attend this hearing remotely, I will call the lead counsels of each accused as they are reflected in the case name, starting with counsel for Mr. Gucati and then counsel for Mr. Haradinaj. Mr. Rees, please.
Good afternoon, Your Honour. I appear on behalf of Mr. Gucati. I'm assisted by Specialist Co-Counsel Mr. Hugh Bowden.
Good afternoon, Your Honour. Toby Cadman appearing for Mr. Haradinaj, assisted by Mr. Carl Buckley.
Thank you, counsel. And for the record, I am Nicholas Guillou, pre-trial judge for this case. On 18 December, I scheduled a hearing for today for two purposes. First, to allow Mr. Haradinaj to enter a plea on the charges brought against him by the prosecutor and confirmed by the pre-trial judge. And second, to hold a status conference in this case. I will begin with Mr. Haradinaj's plea, but before we proceed with our agenda today, I would like to remind the parties that should they wish to take the floor to raise a specific issue or respond to anything that has been said, they shall stand up if they are in the courtroom or raise their hand if they are attending the hearing via video conference. Should anyone attending the status conference via video conference experience any technical difficulties, please inform the court officer and myself immediately by waving your hand. And if the connection with any of the remote participants fails, we will do our best to reconnect immediately. If the issue cannot be resolved immediately, I may have to adjourn the hearing for a couple of minutes to ensure that the line is reconnected. Let me first start with the plea hearing. On 6 January, further to a request by counsel, I approved Mr. Haradinaj's absence for the second part of this hearing, but ordered Mr. Haradinaj to appear in person or via video conference for the first part of this hearing for the purpose of entering a plea. On the same day, counsel for Mr. Haradinaj informed me that his client refused to attend the hearing for the purpose of entering a plea. Mr. Cadman, before I proceed, do you wish to add anything on this topic?
Your Honour, thank you. We had put in writing the reason why Mr. Haradinaj had declined to attend. He has instructed me that he is declining to attend on the basis of protest, the way he perceives he has been treated, and that a not guilty plea can be entered on his behalf, and he has instructed me to appear on that basis.
Thank you, counsel. I take note of Mr. Haradinaj's refusal to appear before me, and I hereby find that the conditions under Rule 68.4 of the rules are fulfilled for the first part of the hearing to proceed in his absence. Furthermore, by virtue of Rule 92.2 F, I consider Mr. Haradinaj's refusal to attend as a failure to enter a plea, and therefore I hereby enter a plea of not guilty on his behalf on all charges in the confirmed indictment. That concludes the plea portion of this hearing. We will now move on to the first status conference of this case. My goal today is to review the status of the case and to organize exchanges between the parties to ensure an expeditious preparation for trial. In particular, I wish to discuss the status of the specialist prosecutor's investigations, the estimated amount of documentary and testimonial evidence the parties will want to bring to trial, issues related to the disclosure of supporting material to the indictment, additional material intended for use at trial, exculpatory evidence, and protected material. The procedure for disclosure, the redaction regime to be adopted for the present proceedings, and finally, any other issues the parties may wish to raise. I thank the SPO and the defense for their submissions. I will invite the parties to present their views in a concise fashion about each item on the agenda, which I will address individually. There is no need for each party to repeat their written submission in detail. I remind the parties to give prior notice should any submission require the disclosure of confidential information so that we can go into private or closed session. Let me first move to the general questions. Before I give the floor to the parties, I wish to remind them of the general principles of disclosure in the legal framework of the specialist chambers. Disclosure is an inter partes process in electronic form, organized and facilitated through the registry's court management system. Disclosure shall be a priority for the prosecution at this stage, and the parties shall disclose evidence of true relevance to the case and not the greatest volume of evidence. In view of a publicity principle, evidence is registered as public unless there are reasons to classify otherwise. The disclosing party determines the appropriate level of classification of evidentiary items on a case-by-case basis. I first would like to hear from the prosecution on this first topic in the agenda, notably on the status of its investigations, on the amount of evidence it intends to use in the proceedings, and on how many witnesses it intends to call at trial. Mr. Prosecutor, you have the floor.
Thank you, Your Honor. I don't have much to add to our written submission, so I'll give a little bit of a summary, and then I can respond to any questions yourself or the defense may have. As we noted, the investigations are ongoing. We propose a deadline for disclosure, by which time we also propose to finish the bulk of investigations, subject to the caveat we put in, which is, of course, investigations may go on throughout proceedings, and then appropriate applications can be made for disclosure or additional evidence to be submitted. In relation to the amount of evidence for trial, we noted that the indictment supporting materials has all been disclosed. Those were 114 items. We expect that that will constitute the bulk of the evidence we will rely on at trial. However, as proposed in our submissions, we will supplement that by our proposed deadline of 19 February, should that be, of course, acceptable to Your Honor. This week, we also disclosed items which are under Rule 103, so potentially exculpatory items. There were 67 items in the package. 62 of those items have already been disclosed as indictment supporting materials. So essentially, thus far, the total amount of items disclosed is 119. In terms of the witnesses at trial, we are, as we mentioned in our filing, undertaking steps to conduct witness interviews, and at the moment, the estimate which we gave in our filing, which is up to a maximum of 10 witnesses, still holds good in our regard. I don't have anything particular to add unless Your Honor has any questions.
Thank you, Mr. Prosecutor. Now let me turn to the defense for their submissions on what the prosecution just presented and on the item listed in the general question of the agenda. I note that defense for Mr. Haradinaj indicated that it needs 1 to 2 months for investigations, while defense for Mr. Gucati stated that it was not possible to indicate an exact amount of time for investigations. I also note that neither defense can indicate at this stage whether they will provide notice of alibi or any other grounds excluding criminal responsibility. Mr. Rees, please.
Your Honour, I have nothing to add to that which is in our written submissions. I would like the Specialist Prosecutor's Office, however, to acknowledge the matters that we've raised in our written submissions in relation to service of the documentation described in Your Honour's confirmed decision on the indictment as Batch 1, Batch 2 and Batch 3, also referred to in the indictment as the first disclosure, the second disclosure and the third disclosure, collectively described in the indictment as confidential information. Is this Specialist Prosecutor's Office in a position to tell us today when we can receive that material and an estimate as to how much material is involved therein? Once we have that material, that will allow us, we will be in a better position to be able to assist the court in due course regarding the length of time for defence preparations.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honour, I would reiterate the same points. We have indicated, as things currently stand, a rough estimate of 1 to 2 months, but that's based on things as they currently stand. We would obviously need to consider that in light of additional material that the SBO intends to disclose by the 19th of February. So the 1 to 2 months is a rough estimate at this stage, considering that there are still a significant number of unknowns. I would also repeat what Mr. Rees has said as far as batches 1, 2 and 3. Both counsel for Mr. Gucati and Mr. Haradinaj have set out in the written submissions clarification or seeking clarification as to the timing for disclosure of this material. And so I would merely repeat what Mr. Rees has said, and I don't have anything further to add under this head at this stage.
Thank you, Mr. Cadman. Mr. Prosecutor, do you want to address this question now or when we go through each category of material? Maybe we can have a discussion on this now because it's just been raised by the defense. You have the floor.
Thank you, Your Honour. So I will first address the submissions from the Haradinaj defense concerning the 1 to 2 months for investigation. I just have a few points to make in that regard. As Your Honour knows, the Specialist Prosecutor's Office indicated that there should be no reason to proceed to trial in early spring of this year. And the Haradinaj defense responded by saying early to midsummer is more realistic. When it comes to the defense investigations, the prosecution's position is that, of course, they should be conducted and they should be given every opportunity to do so. However, as I mentioned earlier, the bulk of the material that we intend to rely on a trial has by now already been disclosed. The defense has known what this case is about essentially from when the accused were arrested in September last year, and the indictment was confirmed in December. So when it comes to regulating or discussing the timing of the defense investigations, in our submission, they should already be ongoing, and we don't expect that there should be several weeks or months after the disclosure deadline, in particular in view of our submissions, that the bulk of the material we rely on has already been disclosed. I'll now turn to the submissions concerning the 3 batches. All of us here and remotely know that the dissemination of confidential and non-public material is what this case is about. The defense expects the Specialist Prosecutor's Office to hand over, so to speak, the weapons which the accused used to commit the alleged crimes. Doing so would run counter to the purpose for which the proceedings were brought by the Specialist Prosecutor's Office and confirmed in the indictment by Your Honour. I note in particular that as recently as the 24th of December 2020, in two separate decisions, Your Honour found that each of the accused, the risk they may commit further crimes by threatening, intimidating, or putting at risk potential witnesses through disclosure of confidential and non-public information remains. I also note that the Specialist Prosecutor's Office has already provided an investigator's declaration concerning the 3 batches which we are discussing now as part of the indictment supporting material. So that was this Monday. All this being said, the Specialist Prosecutor's Office continues to review the materials, including the 3 batches, in light of its obligations, but the SPO does not intend to disclose the portions of the 3 batches of documents that do not contain public material to the accused. The SPO will, of course, make any necessary applications in this regard in writing, bearing in mind the relevant provisions under the law and the rules, and we will do so well before the expiration of any deadline set for disclosure. And to answer one other point raised by counsel for Mr. Gucati, in relation to the amount of material contained in 3 batches, I can refer counsel to the declaration I mentioned, which is the investigator's declaration disclosed on Monday with the indictment supporting materials. And that document contains a page count for each of the 3 batches. I have no further submissions on this point. As I said, we will be making filings if and when necessary, but I am open to any questions from Your Honour.
Thank you, Mr. Prosecutor. Should there be any exculpatory material in these batches, would they be disclosed according to Rule 103?
Although, as I said, the review remains ongoing, at the moment, the Specialist Prosecutor's assessment is that these materials, the 3 batches, fall under Rule 102, not under Rule 103, and accordingly, certain provisions of the law and the rules continue to apply. And here I'm referring, for example, to Rule 106 and to Article 21.6. But of course, we will elaborate all of this in our submissions.
Thank you, Mr. Prosecutor. I turn to the defense. Mr. Rees, do you want to add anything?
Well, yes. Obviously, there's a lot of material, a lot of information there, and will take us some time to digest exactly what the SPO's position is. But if we are going to get some clarification in writing from the SPOs, their position on this material, what material, if any, is going to be served as evidence that they rely upon, what material they will identify for disclosure to us on the basis of it, either under Rule 102 or 103, or indeed which portions of it they do not intend to reveal to us at all. When will we receive that clarification in writing from the SPO?
Thank you, Mr. Rees. Mr. Cadman, do you want to add anything on this topic?
Certainly. I'm quite happy to await for the prosecutor to respond to what Mr. Rees has just requested. Our request would be the same. I have to express some concern that we're being expected to go to trial on matters so fundamental that are not going to be subject to disclosure. I fail to see how the 2 defendants can possibly be afforded a fair trial in circumstances where a substantial amount of the material is going to be withheld. The other point that I would like to make, and we can of course come back to it, the suggestion that investigations should have started by the defence as long ago as September or December. I mean, the matters that the prosecutor have set out are wholly irrelevant. If we are looking at recent disclosures and the fact that the not the majority, but the fact that additional material is not going to be served until the 19th of February, how we can possibly commence investigations when the material has not been disclosed. I fail to see the point that the prosecutor is seeking to make. And the final point, the prosecutor has indicated that they are still conducting witness interviews, and I have to raise some concern as to the prosecutor's readiness to serve their case. I really think there needs to be some clarification and some fairly strict timelines set down for when the prosecution is going to be serving their case. We can't possibly be expected to commence our investigations in any substance until we know the case against us.
Thank you, Mr. Cadman. Mr. Prosecutor, do you want to answer the question of Mr. Rees regarding the timing?
I'll start by saying that no deadline has been set by Your Honour in terms of disclosure. We propose a deadline, which is the 19th of February, which is a very early deadline. We disclosed the indictment supporting material well in advance of when we absolutely had to. We've already disclosed potential exculpatory material, so it is clear that the prosecution is doing all that it can to ensure the expeditiousness of proceedings. This matter, the disclosure of the 3 batches, falls within the realm of disclosure. Accordingly, those deadlines apply. However, we should be able to file any necessary applications in relation to the 3 batches within the next 15 days. Would Your Honour like me to answer the other questions or the other issues made by counsel? The issue of a fair trial was raised, and the prosecution's position is that the disclosure of the batches has no impact on the fairness of the trial as such. First of all, in the indictment supporting materials, we already provided an investigator's declaration which describes the content of the 3 batches, and that is the material that was relied on in the indictment, and the material based on which Your Honour confirmed the indictment. So the indictment against the accused has been confirmed without the submission of those 3 batches of evidence. It's not that we gave the 3 batches to Your Honour, but not to the defense. The trial is fair because the charges against the accused are clearly set out in the indictment. If we are made to file pretrial briefs, we will elaborate there. There is an analysis chart annexed to the indictment, which, as we mentioned in our filing, could now be provided to the defense. That will provide further notice. But just to be clear, should Your Honour agree with the prosecution that the 3 batches, to the extent that they do not relate to public information, do not need to be disclosed to defense, that would not hinder the fair trial rights of the accused. To provide some further clarity in relation to other matters raised by the defense, the interviews that I made reference to, those are among the group of undertakings which we are currently undertaking as we speak, and also ones which by the 19th of February deadline we aim to provide all relevant evidence. So the 19th of February deadline, subject to the caveats I mentioned earlier, is when the defense should have everything. The defense have raised again the question as to how they should be expected to start investigations, and I don't know if it was lost in my submissions, but the bulk of the material we intend to rely on has by now already been disclosed. The charges are clear. There is every opportunity for the defense to commence investigations. Of course, should we disclose further material, additional investigations may be necessary. But in relation to starting the investigations, the prosecution does not understand why the defense cannot do so already, or potentially could have done so already. Thank you.
Thank you, Mr. Prosecutor. Mr. Rees, please.
Yes, I hope the SPO takes cognizance of our submission in writing, that we will require them to prove that the documentation within batch 1, 2, and 3, as referred to previously, is genuine and it contains protected information. We do not accept that. We have also asked them to disclose the seized CCTV footage of the person or persons making the disclosure of that documentation to the KLA War Veterans Association headquarters. Can Mr. Pache tell us, confirm to us that that will be done, and be done by when, please? We've also raised in the note in our written submissions the fact that the indictment refers to associates, certain others, and others who are alleged to have participated in offences subsequent to the disclosure of that material to the KLA War Veterans Association headquarters. Again, can the SBO tell us when they will identify those persons to us so that we can begin our preparations? We are entitled to know fully the nature and cause of the charges against Mr. Gucati. And until we do so, we're not in a position to begin our preparations.
Thank you, Mr. Rees. Mr. Cadman, do you want to add anything?
Your Honour, just to re-emphasise what has already been stated, what's in the written submissions, and to join what Mr. Rees has said, I don't think we're in a position to be able to put anything further forward until we have greater clarification from the prosecution. And just to re-emphasise my concern, as Mr. Rees has expressed his concern, that how could we possibly be expected to prepare on basis of material that is not going to be held, that is going to be withheld. The prosecution has said that we have a statement from an investigator having analysed that material. That doesn't answer the question. It doesn't answer the question at all. What the investigator says from what she has seen and analysed does not enable us to make any determination and put forward a case as to whether the information is protected information, which is the substance of the case. I really don't see how the prosecution can persist with such position, and Your Honour will have to ensure that there is clarity on the prosecution's position before we go forward.
Thank you, Mr. Cadman. Mr. Prosecutor, for a final reply on this matter.
I'll take the points made in turn, starting with the first, and I can respond simply by asserting that the prosecution will meet the burden in that it will establish that the documents did contain confidential and non-public information. In relation to the CCTV footage mentioned by counsel, the disclosure is ongoing. As I said, although we have already disclosed material, we did so well in advance of the deadlines, so we should be given some room to effect further disclosure. Turning to the submissions, both in writing of the Gucati defense and also today, insofar as the Gucati defense is challenging the form of the indictment, which in our submissions, that is what it amounts to when counsel speaks of the associates and other persons, pursuant to Rule 97, reasoned submission should be made in writing, and the SPO will respond accordingly. On this note, I do have to take the time here in court to clarify something made in those written submissions in this regard, and that is that contrary to what for us are misleading submissions made by the Gucati defense, the Specialist Prosecutor's Office has made no attack on any members of the media. The Specialist Prosecutor has in fact issued a public statement in which he commended ethical journalists throughout Kosovo who refused to publish the documents provided to them. And in our submission, this reference by the defense in conjunction with the reference to who these associates or others named indictments are, by putting or attempting to put the media into play, is an attempt to deflect attention from the charges which were brought against the accused and not anybody else. In relation to the points made about the disclosure of the batches, I think I've exhausted all I have to say. I've made it clear that we will file written submissions if and when necessary, and we can take it from there. And I just, one final time, reiterate that the main evidence, the crimes are caught on tape. There is other evidence, sure. Most of that evidence is already with the defense, and I will not get into further debate as to defense investigations and the ability to start or have started them.
Thank you, Mr. Prosecutor. Does anybody want to respond, or we will wait for your submissions in due course? No.
Well, I will
Mr.
say
Rees.
this, Your Honour. Apologies. We have referred to the fact that the indictment alleges others, associates, certain others, and others who are said to have participated. And we note that in Your Honour's decision on the confirmation of the indictment, Your Honour made it clear that the SPO was accusing certain members of the press, broadcasters and news organisations as so participating. And what I'm asking for at this stage is further information disclosed to us so that we can understand fully the nature of the case against us. I make it perfectly clear, as I did in the written submissions, that we, the defence, Mr. Gucati, refutes that attack that's been made by the SPO upon the media and others in Kosovo. And I am asking for the SPO to make clear who it alleges those persons were, so that we can fully and clearly understand, as we're entitled to, the nature and cause of the charges against Mr. Gucati and can prepare accordingly. Until that's done, we are still not in a position to understand clearly and fully the nature and cause of those charges.
Thank you, Mr. Rees. Mr. Prosecutor, and for a last intervention on this topic, and then we'll move to the next item in the agenda, please.
Yes, all I can say is to reiterate that the Council's submissions as to who these associates may or may not be, in our opinion, is a matter to be filed in written submissions as one of the preliminary motions, which there is still time for the defence to do, because we consider that to amount to a challenge to the form of the indictment. And in relation to the assertion in the written submissions, which Council repeated now about an attack by the Specialist Prosecutor Office on the media, I've already said my part. This is absolutely not the issue. The issue is that the Specialist Prosecutor's Office brought charges against the accused, and that is what Your Honour will be ruling upon.
Thank you, Mr. Prosecutor. Now let me move to the second item in our agenda, which is the supporting material to the indictment. I take note that the SPO disclosed all indictment supporting material to the defense on 4 January 2021, together with Albanian translations thereof, and that no redactions were applied to the material. I invite the SPO to give any further submissions on the disclosure of the supporting material to the indictment, notably on the overall amount of evidentiary material and any other details that the SPO wishes to provide. Mr. Prosecutor.
In terms of the disclosure of indictment supporting material, as Your Honour mentioned, we have completely fulfilled that obligation very early on in the day, which was last Monday. As set out in our filings and as clear from the disclosure itself, there were 114 items. I have nothing further to add about the items as such, unless, of course, Your Honour has questions. And I'm limiting my submissions for now to the indictment supporting materials. Okay.
I just have one question here. Can you confirm that the detailed outline doesn't need any redactions, and then that it can be reclassified?
Yes, Your Honour. I note that we were invited to make submissions about protective measures, I believe it was by the 6th of January. We made no such submissions as foreshadowed in our 4th of January filing, and that is indeed because for the purposes of provision to the defence on a strictly confidential basis, the annex to the indictment containing the analysis chart, let's call it that, can be provided to the defence, so we have no objection to that. Your Honour could rule that that could be done immediately. To be clear, to the defence, not public.
Thank you, Mr. Prosecutor. I turn to the defence now on the supporting material to the indictment. Mr. Rees, if you have any submissions.
Nothing to add to the position I've set out in the written submission, Your Honour.
Thank you, Mr. Rees. Mr. Cadman.
Nothing to add, Your Honour, and we've already indicated to the SPO that we're content with the draft table that they have proffered as well.
Thank you, Mr. Cadman. Now let me move to the additional material intended to use at trial. I take note that the SPO is expecting to be ready to disclose further material under Rule 102.1b by 19 February 2021, or in any case, no later than 30 days prior to the opening of its case, subject only to any protective measures being granted. I invite the SPO to give any further submissions on the estimated amount and type of material it intends to disclose, the redactions that will be required, and any other details the SPO wishes to provide. Mr. Prosecutor, you have the floor.
I don't have much to add to the submissions. In the written submissions, we highlighted that we would be disclosing essentially more of the same type of material. The interviews could lead to witness statements, and of course, those will be disclosed. Redactions, for now, the material that has been disclosed has not required redactions. Moving forward, that may be the case, and of course, we will apply the redactions consistent with whatever regime is adopted by Your Honor. I can give a little bit of further indication, perhaps also to appease counsel who raised this matter earlier, in terms of the witness interviews we're conducting. And keeping it very general, I can say that that will go to the impact of the actions or the alleged actions of the accused. So the material that we have disclosed thus far already captures the bulk of that which the prosecution will rely on in terms of the specific conduct of the accused. There may be more. It would be of the same nature, but the bulk has already been disclosed.
Thank you, Mr. Prosecutor. I turn to the defense. Mr. Rees.
Your Honor, in addition to the written submission, I just want to reiterate that it's not clear to us whether the SPO is proposing the 19th of February to disclose any material as a result of their analysis of seized electronic items. If that is so, then I have nothing further to add. If they're suggesting that material that will be the outcome of the ongoing analysis of seized electronic items that they refer to in their paragraph 10 submission, if that's excluded from that 19th of February proposal, there should be a date set down for the SPO to provide us with material that derives out of that analysis. In other words, they should be given a target date to complete their analysis of those seized electronic items.
Thank you, Mr. Rees. Mr. Cadman.
Thank you, Your Honor. Only to just re-emphasize the point that's in the written submissions that we do not consider 30 days before the opening of the prosecution case to be sufficient. We would ask that the prosecution be directed to serve their material as and when it's available, and that not to be contingent upon when the start of the trial is likely to be.
Thank you, counsel. Mr. Prosecutor, do you want to reply to the defense?
Turning to Mr. Gucati's counsel first, I confirm that the self-imposed thus far deadline of the 19th February, by that time we do intend and hope to disclose the material related to the seized items. That, of course, to some extent depends on third parties, and should that become unrealistic in due course, we would notify Your Honor of that issue. In relation to the 30 days before the start of the trial raised by counsel for Mr. Haradinaj, we have made our submissions in which we said that 19 February we would be ready, subject to, of course, that being close to the start of proceedings. It is at this stage premature to say that 30 days is not enough before trial after the end of the disclosure, because disclosure is ongoing. However, as I've mentioned many times, the bulk of the disclosure, we believe, has already been effected thus far. There may be additional material, and of course, the 30 days being adequate or not can be revisited in due course.
Thank you, Mr. Prosecutor. Let me now move to the next item in our agenda related to the evidence material to defense preparation, which is the Rule 102.3 material. I would like to remind the SPO that disclosure or inspection of evidence such as statements, documents, photographs, or tangible objects material to the defense must be disclosed without delay. What is considered material to the preparation of the defense must be understood broadly. I also remind the parties that disputes as to the materiality of the information, as claimed by the defense, must be submitted immediately to the pretrial judge for resolution. I take note that the SPO anticipates providing the defense with detailed notice of evidence material by 19 February 2021, like for the previous category. I invite the SPO to indicate for this category an estimation of the type and amount of material, the redactions that will be required, and any other details that the SPO wishes to add. Mr. Prosecutor.
Because the review is, of course, ongoing and we are at an early stage, anything I say now will be provisional, but I can say that in terms of the type of material, it will reflect that which has already been disclosed. We've had quite a few audiovisual exhibits accompanied by transcripts and translations. We've had some documentary materials such as articles and that kind of thing. We expect it to be more of the same in relation to type. In relation to amount, I don't think I can actually provide an estimate at the moment because that depends on not only what we are reviewing for the purpose of Rule 102.3, but also for other purposes of disclosure. But again, I don't expect large volumes of material to be disclosed under this heading. And the same can be said for redactions. Thus far, we haven't applied any redactions to any disclosed items. Items of a similar nature, such as videos which are obtained from the public domain, tend not to require any redaction. So should such material fall under this rule, then redactions would not be necessary. If, on the other hand, for example, witness statements are assessed by the prosecution to fall under this rule, then the redactions would be necessary and would make the application as instructed by Your Honour.
Thank you. Mr. Rees, please, do you have anything to add in this category?
No, I don't. Thank you, Your Honour.
Thank you, Counsel. Mr. Cadman, please.
No, thank you, Your Honour.
Thank you. Let me now move to the Rule 103 material, which refers to exculpatory evidence. I remind the specialist prosecutors that it must disclose immediately to the defense any exculpatory evidence as soon as it is in the custody, control, or actual knowledge of the SPO, which may reasonably suggest the accused's innocence or mitigate the guilt of the accused or affect the credibility or reliability of the specialist prosecutor's evidence. Disclosure of exculpatory evidence is a continuous obligation, subject only to protective measures when necessary. I take note of the SPO's submissions that a part of the exculpatory material has been disclosed together with the Rule 102.1a material. I also understand that a further segment of such material has been disclosed on 6 January 2021. I invite the SPO to indicate the amount and type of exculpatory material in its custody, control, or actual knowledge, whether redactions will be required, and any other details the SPO wishes to add. Mr. Prosecutor.
Just to clarify, Your Honour, the disclosure which took place on Monday was exclusively of indictment supporting materials. Those were 114 items. On Wednesday, we released another package which was exclusively of Rule 103 materials, so potentially exculpatory. That consisted of 67 items. However, the first package, the indictment supporting materials, already had 62 of them. So essentially, the new documents provided under Rule 103 are 5. We are well aware of our obligations under this rule, and we are, of course, continuing our review. We are expecting that the disclosure of the 67 items under Rule 103 is the bulk of our disclosure under that rule. we will be in a position to disclose the remainder of the items currently in the possession of the prosecution by the next week or two. But again, we do not expect that to be a particularly voluminous disclosure under this rule. As to redactions, once again, none have been required thus far. I'm not certain whether they will be required for the other material within the prosecutor's possession at the moment, but of course that will be made clear to us soon, and if necessary we'll file a request in that regard. And then of course for the material that is not yet in our possession, that would be speculative at this stage from my part.
Thank you, Mr. Prosecutor. I turn to the defense. Mr. Rees.
Nothing to add at this stage, Your Honor.
Thank you, Mr. Rees. Mr. Cadman, please.
Nothing to add, Your Honor.
Thank you, Counsel. Let us now move to protected material, which is the Rule 107 material. I take note that the SPO foresees that the limited amount of Rule 107 material information is potentially subject to disclosure under Rule 102.3. I would like the SPO to notably indicate the amount and type of material that still requires clearance, whether the SPO has already taken steps to obtain the consent of the information providers to disclose such material, or whether such steps are foreseen in the near future, whether the SPO intends to apply to the pretrial judge to be relieved in whole or in part of its obligations under Rule 102 and or 103 of the rules to disclose the initial material, and whether redactions will be required. Mr. Prosecutor.
As for the type of material, it is documentary, that which we have identified thus far. Of course, there may be other, but it's becoming clear what kind of material we have disclosed will also be reflected, and that is which we expect to disclose further. In terms of whether the steps are ongoing, yes, they are ongoing, and we are obviously in our interest as well to make sure that we receive the adequate responses. Again, this necessarily depends a little bit on external parties, but should we not be able to meet a deadline, we will notify the judge well in advance. We aim to be able to do so, and we will communicate that to our partners. In terms of a request for relief of obligations, it would be premature for me to make an assertion as to whether or not that is necessary at this stage, but of course, if necessary, we will make one. Right now, I don't think so. It could be later on. And as for redactions, that again depends on the communication with the external partners and the other review of material that is ongoing.
Thank you. Does the defense has anything to add regarding this category of material? Mr. Rees.
Thank you.
Mr. Cadman?
Not at this stage, Your Honor.
Thank you very much. Let us now move to the procedure for disclosure. In its submission, the SPO indicates that it supports the adoption of the regime similar to the one in the Mustafa case. I invite the SPO to give further details on this topic and all the parties to comment on the Rule 109C chart proposed by the SPO. Mr. Prosecutor.
Yes, Your Honor, I have nothing further to add to the submissions. It seems that the chart which we sent out to the defense has been well received. We will, of course, engage in further inter-parties communications before we come back to you about the chart that we addressed. But for now, I have nothing else to say on this topic.
Thank you. Mr. Rees, please.
Nothing to add, thank you.
Mr. Cadman?
We've already indicated our position on the chart. We've indicated our position in the written submissions that the Mustafa ruling is the one that should be applied. Nothing other than that, Your Honor.
Thank you very much. And Mr. Prosecutor, just to clarify, you have shared the same type of chart as in the Mustafa case, correct?
Yes, it is essentially identical. I believe that there is one column which may be different from the Mustafa proceedings, but in the main it is the same, and of course, Your Honor will see it as soon as we have reached an agreement.
Thank you very much. Now let us move to the last item in our agenda, which is the redaction regime. In adopting a redaction regime, it is necessary to ensure the efficiency of the disclosure process while striking a right balance between the duty to protect the interest of the victims and witnesses and upholding the rights of the accused. In its submission, the SPO requests that the pretrial judge adopt the redaction regime applied in the Tachi et al. Case. Pursuant to this regime, in order to avoid multiple redisclosures of the same evidence, the disclosing party does not need to disclose the relevant material concurrently with the request for non-standard redactions. I invite the SPO and the defense to make further submissions on this topic, and I specifically ask the SPO to explain the reasons why it prefers the Tachi et al. Regime as opposed to the Mustafa regime indicated in the order, given that the amount of redactions is expected to be way more limited than in the Tachi et al. And I would also like the SPO to indicate if the preference for the Tachi et al. Regime also refers to the 10-day timeline for submissions of the opposite party and Witness Protection and Support Office, rather than the 5 days that we have in the Mustafa regime. Mr. Prosecutor.
Yes, Your Honor, the sole reason or the sole reasons that we expressed a preference for the Tachi et al. Regime is in fact the issue that you've already highlighted, one of which is the avoiding the redisclosure of items. As Your Honor said, and of course the Special Prosecutor's Office concurs, it is envisioned that there will be far less items disclosed in this case. However, redisclosing the same item multiple times is always burdensome and at times confusing. So in our submissions, it would be better if the disclosure would be made once, and that would be after an application is granted, should it be granted. In terms of the timeline, of course, a 10-day timeline is preferable. However, should Your Honor find the 5-day timeline more workable and appropriate, we would not object to that.
Thank you, Mr. Prosecutor. Now I turn to the defense. Mr. Rees, please.
Well, Your Honour, in the original order you made in preparation for this hearing, your order asked us to consider the regime set out in paragraph 73 to 89 of the framework decision on disclosure of evidence in related matters in the case of Mustafa. We don't raise any concerns about that matter and do not object to that regime being applied, albeit we do say this, that in general proceedings, the matter at a very early stage, so if any issues of concern arise as matters progress, we reserve the right to raise them at that stage. In relation to the counter-proposal from the SPO, we still don't see that the SPO has answered the questions, frankly, that you've just asked them, Your Honour, that no real justification given in the context of this case. We say the procedure followed in Mustafa should be applied at this stage by the SPO.
Thank you, Mr. Rees. Mr. Cadman, please.
Thank you, Your Honour. Our position is the same. You had directed us to consider the reduction regime in Mustafa, and that's what we did. We had set out in the written submissions that we see no reason why the SBO has preferred that in Tachi, and I agree, they haven't given an answer to that. We are perfectly satisfied with the redaction regime as set out in Mustafa, and that's our position.
Thank you, Counsel. Mr. Prosecutor, and just before you take the floor, I will just emphasize that the two regimes are very, very, very close. I think the two differences that I've pointed out in introduction of this topic were really the timeline, the 5 days that are in 10 days in the Tachi regime, and the fact that you do not disclose twice at the moment you make your submission. So I think that the rest is exactly the same. Mr. Prosecutor.
Yes, of course, we fully agree with what Your Honour just said, and I thought I was going to say that they're basically the same. So that's one reason. I do note that in our submissions at footnote 18, we did say that we don't object to the Mustafa regime, subject to this one difference. And the difference we pointed out is that about the redisclosure. So that is the reason. We did give a reason as to our preference for one over the other. However, it's not essentially a very big deal for us. Should Your Honor prefer the Mustafa regime, then that's not a major issue.
Thank you, Mr. Prosecutor. Mr. Rees?
I have nothing to add.
Thank you. Mr. Cadman?
No objection to that.
Thank you. Before we discuss about the next status conference, at this point, I would like to ask the parties if they have any other issues that they would like to raise. And I remind the parties to give prior notice should any submission require the disclosure of confidential information. Mr. Prosecutor.
Yes, Your Honor, two issues. The first is I'm going to take this as an opportunity to respond to submissions made in writing by the defense for Mr. Gucati. And in the written submissions, the defense seems to imply the SPO may have somehow been associated with the unknown individuals who provided the confidential and non-public documents to the KLA War Veterans Association. And they also cite to a European Court of Human Rights case, which essentially concerns entrapment. And I just wanted to put it on the record that the SPO unequivocally rejects this completely unfounded implication. As alleged in the indictment, and as will be shown at trial, it's the accused who have incited crimes, and any attempt to deflect attention from that matter will fail. The second issue I wish to raise is just to note that in the interest of the expeditious of proceedings, should Your Honor be inclined to follow the procedure set out in Rule 72, the prosecution would not be opposed to such ruling.
Thank you, Mr. Prosecutor. This is noted. I turn to the defense. Mr. Rees, both on what the defense just, the prosecution just said, and if you have any other topic we'd like to raise, please.
I will simply repeat that which we have put in our written submissions and that which we have repeated earlier. We put the prosecution to strict proof that the documentation seized and referred to as batch 1, batch 2, and batch 3 previously is genuine and contains protected information. And we have put in the written submissions that we require the SPO to demonstrate the origin and provenance of the same by way of an audit trail from their creation of each of those documents to its arrival at the KLA War Veterans Association headquarters. In light of what has just been said on behalf of the SPO, I take it that they have no issue with so demonstrating, and that they will do so, and we will be able to scrutinize what has been asserted by the SPO in those oral submissions. I look forward to receiving that material so that we can scrutinize it and satisfy ourselves that what has been so boldly asserted can be supported.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honour, thank you. Only to just very briefly come back to the point of Rule 72. Obviously, this will have to be something that we may come back to in the future. Obviously, this is not a matter which is suitable for shortening of procedures. But of course, that may be something that we need to come back to in due course. So I have nothing further to add, which hasn't been already stated or is not in our written submissions of today.
Thank you, Mr. Cadman. Mr. Prosecutor, do you want to add something briefly, please?
Yes, very briefly, just in response to the counsel for Mr. Gucati, all I will say is that the prosecutor's office is confident it will meet its burden under the law and that it will satisfy the requirements for the crimes with which the accused have been charged.
Thank you, Mr. Prosecutor. I would like to ask the parties now for their views on a suitable date for the next status conference. As the SPO indicated that they would finalize disclosure on the Rule 1021B and Rule 1023 material by 19 February, I suggest that the second status conference will be held on a date between 24 and 26 February. So can the defense and the SPO indicate their availability for these dates? And I also note in this regard that should counsel of the accused wish to participate via video conference, written notice to the registry must be provided 24 hours in advance of the relevant hearing so that arrangements can be made. Mr. Prosecutor.
We will be available on the dates Your Honor mentioned. Any of the dates will do.
Thank you. Now I turn to the defense. Mr. Rees, please.
Your Honor, clearly we didn't have notice of those proposed dates previously. At the moment, each of those dates would cause me a difficulty, although I do not know to what extent Mr. Bowden, Specialist Co-Counsel, can assist on those dates.
If I may, Mr. Rees, we can take some more days to determine the exact date, but on the general idea of scheduling the status conference after you receive all the material, a couple of days after, is it something that seems suitable for you? Or do you wish it to be before, or do you need more time after you receive the material? I think that's the main idea.
We're certainly content to have a further status conference. To what extent we'll be in a better position?
Your microphone is off, Mr. Rees, I think.
Apologies.
Yeah.
Certainly, Your Honor, we're more than happy to have a further status conference in the week shortly after the 19th of February. To what extent we'll be in a position to assist the court further at that stage depends obviously on the material that has been disclosed. It would be more convenient for me if any further status conference around that date took place towards the end of the following week, so perhaps the 5th of March.
Thank you, Mr. Rees. Mr. Cadman, please.
Your Honor, I'm available on the latter date that Mr. Rees has mentioned, and I think we may need some days after the disclosure to consider the position before a status conference. So certainly it would be convenient to cancel for Mr. Haradinaj at the beginning of March rather than end of February.
Thank you, Mr. Cadman. Unless any party has anything to add, this concludes today's public hearing. I thank the parties and the registry for their attendance, and I also thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. The hearing is adjourned.
All rise.